Mr. Chair, we're live.
Okay, welcome everybody to our March 31st meeting. We can begin with a discussion of the minutes from our meeting of February 24th. Are there any comments or questions about the minutes? Hearing none, I will entertain a motion to approve the minutes for February 24th.
So moved, Cavello.
Is there a second?
Second.
Okay. All in favor, raise your hand. Say aye.
Aye.
Aye. Any opposed? Seeing none, the minutes are adopted unanimously. I'm going to turn to Leticia now to give us an update on a number of items.
Good morning, everyone. I want to just update everyone on a couple of the outreach initiatives that we participated in the past month. We held 2 roundtable discussions on the topic of redesigning the Commission's website and updating our electronic lobbying filing system. I want to thank the participants who attended the roundtable discussions. They included members of lobbying firms, good government groups, consultants, and state agencies. So I want to thank them for the valuable input and insight, and we'll be incorporating some of their comments and suggestions into the redesign of the new website and the electronic lobbying filing system. One of the other items that we worked on this month in furtherance of one of our primary responsibilities to educate state employees on their obligations under the Public Officers Law and to facilitate compliance with those laws was the expansion of our 1-800-87 ethics hotline. We've added a new feature. It's an option for advice and guidance, and it'll connect the caller with an attorney from our office. So that is a new option that we've added to our existing hotline. We're also currently engaged in developing guidance addressing the question or the line between consulting and lobbying. This is an issue that the Commission is very focused on, and we need to bring clarity to this area of the law and to ensure that the public receives the full range of disclosure under the Lobbying Act. To that end, in the coming weeks, we're going to be engaging in dialogue with, again, interested parties, and then we plan to post proposed guidance on our website and then bring it back to the Commission for consideration. Last, I want to just briefly talk about the proposed amended outside activity regulations before I turn them over to Rob Cohen to discuss the substantive changes that we're recommending. I just want to remind everyone that back in December, we presented these draft regulations to the Commission. At the conclusion of our meeting, we posted them on our website for review and to solicit informal comments. We received some comments from the public, from ethics officers, and we have made some of those changes to the regulations, which are at attachment B in your book. They're on the agenda today for consideration. We'd like to submit them to SAPA to enter and initiate the formal rulemaking procedure. Once we do that, they'll be subject to a 45-day public comment period. So at this time, I'm going to turn it over to Rob Cohen, and he can give us an overview of some of the proposed changes.
Thanks, LT. So the proposed amendments to the outside activity regulations are largely meant to clarify the regulations and make them a bit easier to understand. To that end, a number of the changes are really technical in nature. We provided some definitions, for instance, where none exist in the current regulations. We do have some substantive changes. There's 3 of them in particular. I'll go over them very briefly. One is to require that board service as a member of a not-for-profit entity be disclosed on the agency level, even if no compensation is received from such service. Currently, board service on a not-for-profit would only be required to be disclosed and approved if the individual was making at least $1,000 a year in compensation from such board service. So again, the change now would be that if the individual is making less than $1,000 or receives no money at all, for board service on not-for-profit entities, that would need to be disclosed to the agency's ethics officer. Agency approval is not required, it's a mere disclosure requirement. We also require that an individual inform his agency on an annual basis if he is still engaged in a previously approved outside activity. Right now, there's no requirement for that. This would enable ethics officers to be apprised of the outside activities of agency employees, which is especially important if there's, given changes in personnel and rotations of responsibilities with respect to the ethics functions of an agency. And finally, we increased the threshold for requiring JCOPE approval for an outside activity to $5,000 in annual compensation. Right now, it's $4,000. And just to refresh everyone's recollection, if an outside activity generates at least $1,000 in compensation on an annual basis, it requires agency approval. Currently, if the outside activity generates at least $4,000 in annual compensation, it requires agency and JCOPE approval. That $4,000 has been increased to $5,000. The threshold has not been changed since the regulations were enacted approximately 20 years ago. And the $5,000 threshold also aligns with the upper range of Category C in the financial disclosure statement reporting. So those are the changes. And also, I should have said in the beginning, the outside activity regulations, the approval process, I should say, for the outside activity regulations apply only to policymakers, those individuals who have been deemed by their agencies to hold policymaking positions. So that, in sum and substance, are the changes that the proposed amendments to the outside activity regulations make.
Any questions or comments?
When does this go into effect, Ron?
Well, they go out for comment, for public comment, and I believe, I should know this.
Rob, I think that they would be submitted and published in the State Register on April 22nd. Then there would be a 45-day public comment
45.
period. So I anticipate bringing them back before the commission in the June, for the June meeting.
And the informal public comment we received from agency ethics officers was by and large supportive. The comments we received were largely more, I would say, more technical in nature, sort of alerting us to some tweaks that we needed to make in the regulations, which we did.
I have some questions and comments. On compensation, how does this definition differ from what is currently in regulation?
It's not meant to be substantively really any different. We have made some word changes to clarify some of the questions that had been presented to the commission. It's to the extent that there's changes made, the changes in the language are done to reflect what has been long-standing guidance in application of the regulation. So there's not, while there are changes to the wording, there's not really any changes to the scope.
Okay. Under the definition of party, is this a definition that is consistent with what's currently in the election law?
Yes. Yes. So party was, I'm sorry, go on.
No, go ahead.
I'd say party is used in the current regulations. It's not defined at all. So we took the definition from the New York election law.
Was any consideration given to just cross-referencing the election law definition? So should the legislature decide to change it, we automatically move in lockstep?
That we did consider that. That is, we can do that. That was one consideration. A countervailing consideration is that the regulations by not referencing the definition and instead using the words, make it a little more user-friendly. But we certainly can reference the definition.
But these, Rob, the regulations that you have in front of us, but for the tweaks that you have identified earlier after receiving informal public comments, these are largely the same that the staff has presented to us previously, is that right?
Yes.
Okay, so these definitions that we're talking about, we've all had them in front of us before, is that correct?
I believe so.
Thanks.
It's always good that we take a new fresh look at items that come before us. Under the approval procedures for 32.6, Rob, was any consideration given to creating a safe harbor? So if an agency officer requested our guidance relating to an approval and we provided it, that would be sufficient to deal with the fact that we might come back later and say, no, we disagree?
Well, isn't anybody who works for the state able to call us up and ask for guidance, either formally or informally? I mean, that's part and parcel of what we do here. Isn't that right, Rob?
Yes, I mean, from time to time, we have agency ethics officers call us up for asking for guidance on outside activities that JCOP under the regulations does not need to approve. And we provide that guidance, freely and enthusiastically. We encourage agencies to call us up should they have any questions, even if JCOP approval isn't mandated.
Here's the potential problem I see, and it's under 932.6A, 2 in the whole, which is the interpretation of the approving authority is not binding on the commission. And it would seem to me that if the commission has given some form of guidance and the approving authority has taken that guidance, that we not come back in the future and say, no, we actually now disagree.
Well, we've had this discussion before, George, and we have discussed, not maybe on this particular point, but just so that we have some context before Rob answers. You raised an interesting point from a litigation perspective, which is you're positing a scenario where an agency or an employee solicits formal or informal advice. You're taking the view that the informal advice that the commission gives, or the formal advice, is limited to only the facts presented, which is not necessarily a view that I think is what is uniformly shared, because there is precedential value, I think some people feel, to those opinions. But notwithstanding that, George, you're asking, well, what happens if the agency follows Jacob's advice and then the commission decides that they're going to take a different view, perhaps in an enforcement action? And the way I look at that is, what kind of viable enforcement proceeding can be brought if the subject of the enforcement action can say, but wait a minute, I called you up and you told me that this was okay? I mean, I can't imagine a scenario where you get the required votes for an enforcement action under that view. I mean, I think many of us are lawyers. I think we all understand, what makes a viable case and what does not, particularly with, respect to issues of intent. So, I thought it was important to give that context before I let Rob answer if he's got anything to add to that.
Times change, people change, even new commissions come into existence and old ones go out of existence. So it seems to me that if somebody asks, and I would posit it that it should, the safe harbor should only exist if we give something in writing to an approving authority.
I would just add.
I mean, I don't know. We can think about this. I come back to a very practical, real world. We can come up with all sorts of scenarios and hypotheticals, but in the real world, whether it's this commission or some other commission, if you're going to litigate a charge that somebody violated the public officers law, and the agency bringing the charge, whether it's formal or informal, gave advice, I'd look to the trial lawyers. I mean, Paul's nodding his head next to me. I'd look to the trial lawyers here and say, what's the likelihood of JCOPE or some successor agency succeeding? I think we all agree it's pretty much close to zero. So I think we can think about this. And I asked the staff to give it some thought. We can go ahead and vote on these today, of course, and submit them to the SAPA process, and then to the extent that there are additional tweaks that need to be made, we can always do that. But it may be something that we want the staff to give some further thought to in light of what George's questions were, and I think in light of the comments that I've raised. Go ahead, Marvin.
On a more mundane level, Rob, where are these forms? How does one access, for example, this outside activity approval form? There an approval form that we propose for the agencies to complete, and if there are such forms, should they not be annexed?
Well, it's a good question. The forms, the current form is available online on our website, and the agency ethics officers know how to access that. We have sent them emails, update emails. When we've updated the form a few times, we've sent them the PDF of the form and also a link to the website. So we have a revised form which it has no change in substance whatsoever from the original form. It has, the revised form has a set of instructions at top. It just purely clarification. There were some outdated fields in the current form. There's some outdated fields, like they asked for a home address and things like that we never use. So it's purely, the revised form is purely technical modifications, and that will be, once the regulations are finally approved by the commission, the revised form will replace the current form.
Shouldn't we see the revised form? If there's substance, any substance attached to the revised form, when we approve, shouldn't we approve the entire package? I'm happy to circulate it, sure. I mean, okay. Is there an agency form? In other words, are we proposing that if the agencies grant approval where they are in a position to do so, shouldn't we approve that form or have that on our website?
Another good question. So to be clear, the current form and the proposed revisions to the current form are only used when JCOPE approval is required.
Right.
Agencies have we've left it, and historically predecessor agencies have done the same as well, have left it to the individual agencies to come up with their own forms.
And the reason I raise this, Rob, is exactly this too that we're talking about. The interpretation shall not be binding on the commission. If we prepare a form that the agency must follow, it might be a more orderly process, and we wouldn't have agencies preparing different forms based on calls they make or their view of the law, et cetera. By putting an agency form onto the website and making it part of this new rule, these new rules, we can get, I think, better uniformity across the board.
Well, your point is well taken. I think it's probably best to hold off on that decision. We can circulate the form, and you'll see what the form is. The form is really just for informational purposes. It's really more in the nature of a cover sheet, and it always has been. So it just requires, name, email, address. There's a couple signatures and some instructions. So the form is really more in the nature of a cover sheet. Maybe form gives it almost too much substance. And it's something we can certainly consider.
Well, what I was referring to more was the agency form.
So Commissioner
An
Jacob,
agency form would say, seek to elicit information from the agency ethics officers to who he consulted what went into his determination of approval. And he signs that. There is an agency form that is signed not only by the employee, but the agency head. Just to have more uniformity in the system, because I think what you said, Dan, and what George has been saying is, especially if you say shall not be binding on the commission, we can achieve greater uniformity and have less headaches in the future, perhaps, if we devised an agency form for the employee and for the agency head and made it part of these regs so we understand what's going on out there. I mean, people can come to different conclusions on what's permissible and what isn't.
Without a doubt, a form like that would provide more uniformity. I'm not sure if there's a problem, though, that necessarily needs to be addressed. Agency ethics officers, I would say, almost without exception, are very conservative in nature. And when there's ever any question, they either come to us or they say no. That's their inclination, is to not get close to the line. So while the form that the agencies could use might provide some uniformity, I'm not sure if it's a problem that's necessarily in need of a solution. And also, some of the agencies are so different from one another that we've generally left it to the agency to develop its own internal practices and procedures.
Look, you're the experts. I'm just throwing it out. If it makes sense, then we ought to come to the conclusion of doing it. If it doesn't make sense, the staff that is out there interacting with these agencies all the time, I leave it up to you.
Commissioner Jacob, one of the very important reasons for why we leave it to agencies as well is agencies often have more restrictive rules than what we've adopted. And so if we were to have or develop one form, it might not capture everything that they want to have disclosed to them and to consider in their approval process. So we would have to balance that. And these regs are very clear that it doesn't prevent agencies from adopting their own rules with respect to outside activities. So I think these are the very reasons that we've contemplated and decided to keep the form separate from the actual regulation. I think these are all good questions and commissioner input into the forms, and maybe we could have a model form that agencies could consider using. But I think we want the flexibility to change the form as we see how it works and if questions come up and things like that outside of the regulatory process. So we could move forward with the proposed regulations and consider what the forms are. The commission can look at the forms, give us comments. But that way we will always have the flexibility to make small changes to the form as needed. And who knows, down the road we might be able to make this process electronic and more efficient and things like that. You want the flexibility to do that. So again, I think there are reasons to think about whether we should have a form for agencies' approval, but maybe there are reasons against it and we need to give that more thought.
Thank you.
I have one more question. It's actually piggybacking on where Marvin was going on uniformity, and it deals with 932.7B. Has it always been that we permit the agency's ethics officer to determine when I'll call it the recertification is made?
No, well, the current regulations do not require, under the current regulations, if an individual gets an outside activity approved, let's say 5-10 years ago, and that individual's outside activity doesn't change and her responsibilities or titles do not change, there is no requirement under the regulations for any notification to the agency that that individual is still conducting the outside activity. So this is an entirely new requirement. I didn't recall it before. But what came to mind, and going where Marvin was going on uniformity, is that while we can keep the language, was any consideration given to putting some kind of outside limit, like 30 days? So it automatically goes on some kind of tickler list. So, in either direction, within 30 days of the prior approval. So we do have some agency consistency. We did not consider that specifically, but we did consider that sort of more generally. And the problem is I think that would create a huge headache for agencies, a huge administrative headache, because outside activities are not, it's not like, outside activities can be approved. An agency could have 6 different approvals coming in from JCOPE in 1 month, or 10, or none. So the agency ethics officer then could conceivably have to keep track of these deadlines for hundreds and hundreds of employees, all of which are different deadlines. So we left it up to the agency to devise a way to facilitate compliance with this requirement.
Yeah, I'm thinking more, Rob, in terms of the individual who has to go through the process, knowing that if they got something today, the end of March, that within 30 days next year, the end of April, they have to go back to the agency officer. I'm more concerned about the individual here, not letting it fall through the cracks.
I understand. The thinking here again in 932.7b was to, let's enable the agency to help facilitate compliance. These agency ethics officers want to make sure their employees are in compliance with the ethics laws and the regulations. So the idea was to leave it to the agencies, which, and some agencies, by the way, already have this requirement in place. Not all, but some. So again, it was to leave it to the agencies to determine the best way from their perspective to make sure that individuals are in compliance with the regulations. And again, this provision here is one of disclosure and notice. If an individual doesn't comply with this, it doesn't mean that the individual is necessarily violating any ethics laws. This is really for the agency ethics officer's benefit.
Yeah, but it's the kind of thing, Rob, that during an internal audit, that internal auditors like to see consistency. So that's all I'm striving for. That's all the comment is striving for.
Commissioner Weissman, I think it's a good idea, and I think we could give it more thought. I think one of the issues is, obviously, as you know, we're talking about, several different types of agencies of different size, different types of operating systems, and often work on different schedules. For example, SUNY and the academic institutions operate on different calendar years, and when they sort of do their traditional administrative functions might be completely different than when, I don't know, docs or someone does its. And in addition, some of the commissions and boards just don't meet as regularly as others. And so, any date that we pick might not work with whatever their traditional institutional deadlines are. So I think those are things that we would need to give more thought to. Of course, we could move forward with the rulemaking process today, submit them out for public comment. While this public comment is going on with this version, we could ask some agency ethics officers these questions. We can always amend the regulations again and put them out for another comment period. So this would just get the process moving forward. Again, right now, there is no annual disclosure that's required. So until this amended version is put into effect, right now, this doesn't happen. So the commission may want to consider moving forward.
Monica, this is one of the reasons I'm raising it, because it is, at least in my mind, a substantive change. I honestly don't believe that fiscal years have any play in terms of somebody applying for this type of dispensation. It can happen at any time, whether it's an April fiscal year or an academic fiscal year, or I don't know where all the authorities. I don't know if they're consistent now with their fiscal year, but it's whenever these things come in, they come in.
I don't think that, I didn't understand Monica to be saying that the issue is driven by, when decisions are made on a fiscal or calendar year end. I understood her to be saying that different agencies have different, and authorities have different meeting schedules. Some are larger, some are smaller, meaning that those who make the decisions about these kinds of exemptions are not necessarily going to meet it all at the same time. And I think that her suggestion that if we move forward with the regs today, as we've done in the past, with these kinds of discussions about pending regs, we can solicit during the public comment period, additional views from the agencies, and the staff can take the questions that have been raised today and come back to us, at the expiration of the 45-day period. And at that point, to the extent that the commission feels that additional changes need to be made before the regulations, go into effect, we can do it at that point. I think that's what I understood Monica to be saying.
Sounds good.
So, unless there are any other questions or comments about the draft, then I appreciate the excellent questions that the commissioners posed. Thank you, Rob, for a very thorough and cogent briefing. I'd entertain a motion to adopt the regs and move forward with the SAPA process at this point. I think Commissioner Jacob is moving. Is there a second?
Second.
Commissioner Castellero. All in favor of the motion, raise your hand and please say aye.
Aye.
Any opposed, please raise your hand and say nay. All right. Hearing none, the motion is adopted unanimously. Thank you again. At this point, if there is no other new or other business, I will entertain a motion for the commission to enter executive session pursuant to executive law, section 9419, subsection B.
We're having so much fun, we don't want to move.
Commissioner Jacob moves. Is there a second?
Cavello.
Second.
Commissioner Ross seconds. All in favor, say aye and raise your hand.
Aye.
Aye. Are there any opposed? Seeing none, the motion is adopted, and we will now enter into executive session. When we complete our work in the executive session, we'll return to a public session, and to the extent that the law permits, we will provide a summary of the work that we undertook during our executive session. Thank you very much.
Yeah.
All right, Mr. Chair, we're back live.
All right. Thank you, Commissioner Cavello. During our executive session, the Commission discussed a number of investigative matters. We authorized a substantial basis investigation. We closed the substantial basis investigation. We authorized the staff to communicate with third parties in connection with information related to investigative matters. At this point, if there is no other business before the Commission, I will entertain a motion to adjourn the Commission's meeting.
Motion.
Is there a second? All in favor? Raise your hands. Any opposed? Raise your hands. Seeing none, the motion is granted and we are adjourned. We will see you next month, everybody.